Welcome to Bed Crime Stories podcast. I'm your host, T. Good morning, good afternoon, good evening, bed crimers. As always, I wish you the best. To anyone new here, a warm welcome. Thank you for checking out my channel. Let me just ask that after listening to or watching this video, if you learned something or enjoyed it, please do me a favor and smash that like button. Now, let's dig in. This morning, Bryan Kohberger appeared in the Latah County Courthouse for his arraignment hearing. I'm including the full hearing at the end of this video so that you can watch it in the event you weren't able to catch it earlier. Kohberger came into the courtroom this morning wearing his orange prison garb and a serious expression on his face. The only thing that stood out to me about his appearance was that his hair was longer. It was hard to see if he'd lost any weight due to the baggy prison ensemble. As Kohberger walked in, he did briefly glance at the gallery where the families of victims Kaylee Goncalves and Maddie Mogen were sitting. From Kaylee's family, her father Steve, Mother Christy, and sister Olivia and Olivia's baby were present. Ethan Chapin's family and Bryan Kohberger's family were not in attendance, but they may have been allowed to peek in via Zoom. It's unclear if Xana Kernodle's family, if anybody from it, was there to represent her. As Kohberger sat next to his defense attorney, Ann Taylor, he made many movements with his mouth, and the muscles in his face appeared to tense. To me, this spells nervousness and anxiety, but that's just me. During the arraignment, the judge reiterated the charges against Kohberger: 4 counts of first-degree blank and 1 count of felony burglary related to the brutal crime that took the lives of Kaylee Goncalves, Madison Mogen, Xana Kernodle, and Ethan Chapin. When asked if he understood his rights and the charges, Kohberger very clearly and in a strong, steady voice said, yes. This made him seem very measured, very coherent, somewhat confident. Unfortunately, the judge mispronounced some of the students' names while reading the charges. He referred to Kaylee as Kayla, and he had to repeat Xana Kernodle's name 4 times. But the judge also apologized, saying, quote, "I'm sorry, this is hard," end quote. Unfortunately, after the hearing wrapped up, multiple news outlets reported that Kaylee's sister Olivia expressed the family's frustration to a representative of the court over Judge John Judge's failure to identify Kaylee by the correct name multiple times. I'm sure that would be very hard. It probably comes across as disrespectful to the family. Maybe they're thinking the judge should have researched the correct pronunciations before showing up in court today, especially knowing how high profile this case is. On a particularly sad note, Brian Entin was in the courtroom, said that family members cried as the judge read their loved ones' names, and you could hear Olivia's baby cooing in the background. As Kohberger was told he could face life in prison or the death penalty, he stared without expression at the judge. We will all find out within the next 60 days if the state decides to have Kohberger face the death penalty. When asked what his plea was, Kohberger elected to stand silent, which means he did not answer himself. This forced the judge to enter a plea of not guilty on Kohberger's behalf. Some people are speculating that by not speaking when it came time to his plea, that Kohberger maybe chose not to answer as a way to be in control. And of course, by forcing the judge to enunciate the plea of not guilty, Kohberger had the judge speaking on his behalf. He was controlling him in a way. Others say that maybe he stood silent because his attorney told him to. Of course, he would have discussed his plea at length with his counsel. Here's what was said on court TV about this whole thing of Kohberger standing silent.
Anything stand out to you in terms of his appearance, his, the fact that he elected to stand silent instead of entering the not guilty plea, which we expected?
Well, the fact that he didn't enter the not guilty plea, or his attorney didn't enter the not guilty plea, is a little bit different. Ordinarily, in these circumstances, when a client is entering a plea, whether it be guilty or not guilty, the attorney lets the court know in advance what the client will be doing. So the fact that his attorney didn't enter a not guilty plea on his behalf is a little bit different. The fact that he didn't look around and stayed straight ahead, that might be at the advice of counsel. I know usually when we come into court, we tell our clients, don't look around, look straight ahead, and let the court know that you're here for serious business.
The Parkland shooter, Nicholas Cruz, did the same thing. In Florida, it's called, instead of saying the defendant stands silent, in Florida, it's the defendant stands mute. And that's what Nicholas Cruz did. And the mentality behind that was that it serves as one of the mitigators, and that is remorse, because we know that Nicholas Cruz admitted to what he did and wanted to enter into a plea agreement with the state to avoid trial. In return of dropping the death penalty, he would plead guilty. They turned that down. He ends up pleading guilty anyway, and they have the penalty phase where eventually he was not sent to death row. But do you think that maybe, Michael, that that's the angle, that he is going to eventually plead guilty here, that might be behind why he chose to, quote, stand silent?
That could be. He clearly had a discussion with his attorney. This was an intentional act on their part, right? This is part of a larger plan and strategy that him and his counsel have put together. It could just be that his counsel told him the only way out of the death penalty is through this judge. It's not through a jury. It's through this judge. You're going to have to prove to this judge that you are remorseful, and this might be the beginnings of that play. We're going to find out soon, and for all we know, maybe that's why they put the trial day so soon, because maybe the court knows something we don't know. There is a gag order on this, so they might know something. They definitely know something we don't know, and that thing might just be that this kid is going to end up pleading out.
Mm-hmm. But do you think, Lateef, the state of Idaho agreed to a plea agreement, given the fact that they do have the death penalty on the books, and this, I can't imagine a crime worse. If prosecutors and family members want to pursue the death penalty, well, they likely won't want to enter into any sort of plea, correct?
Yeah, it just depends. I could see the state entering into a plea with this gentleman based on the fact that they don't want to put the families through a lengthy trial where they'd have to sit there every day. They may have to testify. They may have to hear evidence that is just gruesome. So I could see the state offering a plea in exchange for keeping the families from being further traumatized by having to listen and sit through a lengthy trial.
If that's where the family wants to go, Michael, some families do want that process. They want the maximum penalty allowed by law as a point where they feel as though they're fighting for their loved one.
Yeah, I mean, the victim's advocate definitely are probably involved in this process, right? If we're gearing up for a plea and the court knows that, and the attorneys have, because the attorneys take a sidebar with the judge, right? And they have open conversations with the judge. They don't admit to fault or anything, but they've telegraphed if they're going to plea. I would assume their attorneys have telegraphed this to the judge. The victim's advocate must be involved, and the families of these four kids, they're going to be heard by this judge, and he's going to care more about their opinion than the opinion of the defendant, if in fact he does plead guilty, and if in fact he did in fact do this. So the families are going to play a big part in sentencing.
I found that discussion really interesting because everyone's been saying that Kohberger was going to plead not guilty. Is it possible that he decided to stand silent in a bid to get out of the death penalty? Is he planning now to plead guilty? Is the state of Idaho eager to offer a plea deal to him if he agrees to plead guilty in exchange for taking the death penalty off the table, which would in turn spare the families from having to sit through a very long, upsetting trial. I guess we'll just have to wait and watch. The trial date was set for October 2nd, 2023 at 8:30 a.m., and Kohberger's defense attorney Ann Taylor said she believes the trial will likely last 4 to 6 weeks. However, criminal defense attorney Bryan Kohberger, who is not connected to the case, told Fox News that the trial date is likely to get pushed back. He said, and I quote, "I think you're going to see some discovery disputes, evidence not turned over. I'd be real surprised if this goes on October 2nd. End quote. Thus, it's highly unlikely the trial will really take place starting on October 2nd. And another criminal defense attorney who was on Court TV said he puts the chances of the trial starting at that time at just 5%. Then on the Court TV discussion, they talked a little bit about the evidence, and I wanted to play that for you as well.
It's there. I mean, they have him. They're tracking his vehicle. They're tracking his cell phone. And most importantly, the killer leaves behind a knife sheath. And guess what? This guy's DNA is on the snap of that knife sheath. It seems as though while he said through an attorney after his arrest that he looked forward to clearing his name, that enough time has gone by for a PhD student to connect the dots that, ruh-roh, I'm done. You agree, Lateef?
Well, I agree that there's a lot of evidence. Him saying he wants to clear his name, I mean, that's just, he has to say that at that point. I mean, he can't come in and say, I'm pleading guilty from the beginning of the case. So him saying he wants to clear his name and wants to fight the case, I expected him to do that. The fact that they've gone by way of a grand jury indictment lets me know that the prosecutor wants to get this case moving and wants to get some sort of progress made, either be a plea or taking it to trial.
After the arraignment, there were 2 other hearings that took place today. One of them was to decide if the widespread gag order was to remain in place, and another one was, I believe, to compel discovery. They also discussed the evidence on Court TV against Bryan Kohberger, in particular the DNA on the leather sheath and how powerful that is. We also know that Kohberger's apartment had 2 items in it that tested positive for blood, but we don't know whose blood that is. They do, but we don't. If it belongs to a victim, then it could be another nail in Kohberger's coffin. It could be that Kohberger, seeing all the evidence against him, maybe realizing that it isn't going to be that easy to exonerate himself, and maybe he is considering that guilty plea. Could that explain why the trial date was set so soon? I mean, October 2nd really isn't that far away when you consider how much evidence the prosecutors recently handed over to the defense. Some people continue to poo-poo the DNA evidence, saying touch DNA is unreliable. Personally, I believe that DNA found at the crime scene and then traced to Bryan Kohberger through DNA discovered on an item in the Kohberger family's trash is incredibly powerful. That, in conjunction with the other evidence that we know about, Kohberger's cell phone showing up near the crime scene house 12 times prior to the crime and being so close at one point that it connected to the house's Wi-Fi, and all the evidence we don't yet know about, will likely make for a very solid case. Circumstantial, yes, but still solid. Until the next time on Bed Crime Stories. Did you appreciate this video? Did you enjoy it? If so, smash that like button, subscribe to my channel, and I'll see you next time.
rise. Thanks very much. Please be seated. Good morning, everybody. We have some people on Zoom here too, so we're gonna time it. Okay, let's get up here, please. Thank you. Okay, we are now on the record in State of Idaho versus Bryan C. Kohberger, CR 29222803. Mr. Kohberger is in the courtroom along with his attorney, Ms. Taylor. I believe also part of the team is Jay Logston and Elisa Massa, who is participating by Zoom, I believe. The state is represented by Mr. Thompson, Lake County Prosecutor's Office, or Prosecuting Attorney. Ms. Jennings is of that office too, Lake County Prosecutor's Office. Also part of that team is Ingrid Beatty and Jeff Nye, both from the Idaho Attorney General's Office. I'm John Judge. If you don't know me, I'm the Lake County District Judge, and I'll be presiding over this case. So, Mr. Kohberger, you've already heard a lot of what I'm going to tell you, your initial appearance, but I'll repeat it to you because it's important, and I want to remind you of these issues. So I'll briefly cover your rights, the charges against you, and the maximum penalties if you are found guilty or if you plead guilty. So I'm going to start with the rights. You have a constitutional right to have an attorney represent you throughout these proceedings. If you cannot afford to hire a lawyer, then one is appointed at public expense. Ms. Taylor and her team have already been appointed, so that's taken care of. You have a right to a speedy and public jury trial where the state would be required to prove every element of each charge against you beyond a reasonable doubt. At that trial, you would have the right to cross-examine the witnesses called against you. That means to see, hear, and question them, to call witnesses to testify for you, and if you choose to testify in your own defense. But you're not required to testify because you also have a right of silence. That right is protected under the Idaho and federal constitutions, so you can remain silent throughout these court proceedings, and that can't be held against you in any way. What you do need to remember, though, is that anything you do say other than to your lawyers could be used against you in a later court proceeding. Do you understand that?
Yes, I do.
Okay, thank you. You also have a right to appeal any final decision of the court. In order to exercise that right, you need to file a notice of appeal within 42 days of that final decision, or that right is waived. Also, if you are not a United States citizen, any finding of guilt in this state could have adverse consequences to your legal status. Do you understand these rights?
Yes.
Any questions about the rights?
No.
All right. Thank you, Mr. Kohberger. So, let's go to the indictment. Do you have a copy of the indictment in front of you?
Yes.
Okay, thank you. And you see in the heading your name there. Is that your correctly spelled complete name?
Yes, it is.
Is that the correct birth date underneath your name?
Yes.
Are those the correct last 4 digits of your social security number?
Yes.
All right, thank you. All right, I'm going to read you the charges on the indictment, starting with count 1, burglary. That is a felony under Idaho Code Section 18-1401, and 1403. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did unlawfully enter a residence located at 1122 King Road, Moscow, with the intent to commit the felony crime of murder. Count 2, murder in the first degree. That is a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation and with malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan, from which she died. Count 3, murder in the first degree, a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. This alleges that you, on or about November 13, 2022, in Latah County, unlawfully, deliberately, with premeditation and with malice aforethought, kill and murder Kayla Gonsalves, a human being, by stabbing Kayla Gonsalves, from which she died. Count 4, murder in the first degree. That's a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. Alleging that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation and with malice aforethought, kill and murder Zaina Kernodal, excuse me. This is hard, I'm sorry. Zaina Kernodal, a human being, by stabbing Zaina Kernodal, from which she died. Count 5, murder in the first degree. This is a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation and with malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing Ethan Chapin, from which he died. This is signed on May 16, 2023, by the presiding grand juror. So now I'm going to go to the maximum penalties of each charge, starting with count 1, burglary, minimum 1 year, up to 10 years in imprisonment, fine of up to $50,000 or both fine and imprisonment, restitution for the victim's economic losses resulting from the crime. For counts 2, 3, 4, and 5, murder in the first degree, maximum penalties, life in prison, or the death penalty. Fine of up to $50,000 or both fine and life in prison or the death penalty. Restitution for the victim's economic losses resulting from the crime. Also, additional fine of up to $5,000 to be paid directly to the victim's families. If you are found guilty or plead guilty on each charge, and the maximum sentences are imposed consecutively, that means one right after the other, you could be facing 10 years in prison, followed by 4 consecutive life sentences or death penalties, fines of up to $200,000 and $20,000 to be paid directly to the families, with any restitution resulting from the crimes. Okay. Kohberger, do you understand the charge in count 1 perfectly?
Yes.
Do you understand the maximum penalty?
Yes.
Do Do you understand the charge in count 2, murder in the first degree?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count 3, murder in the first degree?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count 4, murder in the first degree?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count 5, murder in
Yes.
the first degree? Do you understand the maximum penalty?
Yes.
And Ms. Taylor, is Mr. Kohberger prepared to plead to these charges?
Your Honor, we will be standing silent.
And because Mr. Kohberger is standing silent, I'm going to enter not guilty pleas on each charge, counts 1, 2, 3, 4, and 5. Now, at this juncture, the state has 60 days to give notice of intention to seek the death penalty. And Mr. Kohberger has a constitutional and statutory right to a speedy trial. So let's start with you, Ms. Taylor, and then Mr. Thompson to discuss some scheduling.
Your Honor, we'd ask the court to set this trial at the very outside of the speedy trial, right? We're not prepared to do anything but ask the court to do that today.
Okay. Count it out, and that would be.
I have not counted it out, Your Honor, but I believe it would be about November 22nd of this month. Maybe November, somewhere around there. So I'd ask the court to set it for an October trial date.
How long do you think it'll take to try to finish?
My best guess is it would take at least 4 weeks, maybe 6.
So you'd like me to set this for a 6-week trial?
At this point, I would, Your Honor.
Well, and I do so, I will have to get rid of some of the other jury trials I have, but is more critical and more important. So, Mr. Thompson, what's your?
Those trial dates are workable for the state judge.
Thank you. About October 2nd, we started. Okay, for 6 weeks.
Yes, sir.
Anything else we need to address today, Ms. Miller?
Not with regard to the trial setting, Your Honor.
Anything else?
No.
Thank you. Thompson?
Nothing for the state at this time, Your Honor.
All right. So, with that, by the way, I do want to let everybody know, if they don't already know this, that once the grand jury issued the indictment, the preliminary hearing scheduled to